currently.
So it's a class of shadow lobbyists.
If you want to give names to it.
These are shadow lobbyists that we have, and it's a massive loophole, the Carney loophole, and we think it needs to be closed.
How does Canada compare to the rest of the world when it comes to lobbying, and what need to be improved, if anything?
Thank you for that question. We used to be the leaders.
Because you're a liberal insider. I mean, why would you pay someone when you can go directly and do what a lobbyist would do, but you just have a lot more access and a lot more influence? That seems to me to be, at least on the surface, what happened here.
But
This Guy's Garage. Like and subscribe.
And I'd like to welcome our witness for the second hour today from the Office of the Commissioner of Lobbying, Nancy Bélanger, who is the Commissioner of Lobbying. Ms. Bélanger, welcome back to committee. It's been a while.
Good afternoon. Has there been a change in the number of files that or investigations that you've suspended, having referred them to the RCMP? You said the number is 4. Is that a revised number since your last appearance before our committee?
yes, because I believe I have sent 2 in the last, 1 before end of March and 1 this summer.
Okay.
So that's an additional 2.
Okay. And so 2 rested and 2 additional. 2 rested with their office, and there are 2 additional.
2 additional since the last time I've appeared, yes.
Okay. And I would be remiss if I didn't ask if you're able to share any details about the files that you referred to the RCMP.
Unfortunately, I can't. No.
Okay. Thank you. There have been reports that the Prime Minister has met with corporate leaders whose firms are actively engaged with government. Would you consider those kind of meetings the type that would raise transparency concerns with your office with respect to lobbying?
Well, according to the Lobbying Act, every meeting that occurs between corporations about topics that are registrable, so whether it's about policies, programs, financial benefits, would be a registrable subject matter. Obviously, it depends if they meet currently the 32-hour threshold. But yes, if the topics are registrable according to the Act, they would need to be registered.
So all of those meetings, there was, for example, media reports late last week. I think there was a list of individuals from organizations who'd met with the Prime Minister. Those would all be registerable meetings.
They would be registrable if they meet the threshold.
Which is currently
32 hours, but it's changing in January.
In January. So you've said previously that transparency is the foundation for public trust. When someone with substantial private holdings provides policy advice to government, to cabinet, but they're paid to do it, is that still lobbying in spirit, even if it's not contrary to the law?
Well, if I understand the correction correctly, if someone is paid to lobby, then that's a registrable subject matter. But I didn't fully understand the last part. But it would be not in spirit. I'm not sure.
So
if someone is being paid to lobby, and it's about policy development, that's a registrable subject matter. Yes.
If someone is an executive with an organization, they have substantial public, or they have substantial financial holdings in addition to their corporate role, but are brought in to advise government in a non-paid advisory role. Is that not a violation in spirit of what we're trying to do with the Act?
Well, currently the Lobbying Act requires payment. And that will be one topic I would love to discuss with you during legislative review. In Yukon, they've added the concept of directing mind, where they do not require payment. And so that is definitely something I will want to discuss. But if somebody's not getting paid to provide the advice, the Act does not apply currently. Yes.
Yeah, it's a loophole. We've seen this here, where in Mr. Trudeau's government, where they would bring in individuals from the private sector and ask them to advise cabinet. And these individuals are executives with global everything companies, and they're able to give this advice. They're not registered meetings, but they have these private interests that, of course, are going to be reflected in the advice they provide, and Canadians are completely in the dark about that. It's with chairmen and chief executives, and they claimed then that it was of high service to Canada, but certainly it also creates a real problem for Canadians about why the advice is being provided.
Well, of course, I'm a great believer in transparency. Currently, the scenario that you're giving me is not covered under the Lobbying Act, and I think that's something that does need to be looked at.
Do you think that the Act in its current form captures influence peddling when you have unpaid individuals?
If you're unpaid, the Lobbying Act doesn't cover it.
So
currently.
It's a class of shadow lobbyists.
If you want to give names to it, but I'm not in that business. So if I'm just telling you the Lobbying Act does not apply currently, and so it should be transparent. And I do believe if there's payment involved, then it should be, but if there is absolutely no payment, it's a requirement now under the Lobbying Act.
So this is the situation that we have with, pardon me for the interruption, that we have with these meetings that were listed. These CEOs, of course, are not going to be registered to lobby. They're not going to have been paid to be there in the capacity of lobbyists. The very same as Mr. Carney when he was the chair of Brookfield. He was brought in unpaid, but had these personal interests, and so these are shadow lobbyists that we have, and it's a massive loophole, the Carney loophole, and we think it needs to be closed.
There has been questions put to my office in relation to sometimes consultative committees, for example. I'm of the view that for certain CEOs, but for their current employment with their corporation or organization, they wouldn't be sitting at that table. And I have said to them that those need to be registered.
Wonderful. Okay.
So I do interpret it when I'm aware of it and I see names, I communicate with them.
As a commissioner, you work with other people around the world on issues. How does Canada compare to the rest of the world when it comes to lobbying, and what needs to be improved, if anything?
Thank you for that question. We used to be the leaders. Canada has now started to drop a little bit in many of the categories. We still are the leader with respect to the code of conduct. In fact, a lot of people around the world call me to figure out how I came to do the code that we have. But with respect to the Act, we have fallen down. In particular is in areas, for example, spectrum of sanctions in relation to what's disclosed for corporations and organization with respect to beneficial ownership. So we're not as good as we used to be. And now I'm telling you, British Columbia is one of the leaders in this country, in the world, actually, as part of having some excellent elements that require registration and transparency.
Thank you. What type of a sanction would you like to see in the Lobbying Act? And how would those sanctions improve the application of your act that you're responsible for?
I think it would improve it because of the speed in which I would be able to, an event occurs, I look at it, and then I can impose possibly a penalty or obligation to obtain training. Now I have to suspend and send to the RCMP. It takes a lot of resources to investigate, do reports, and send, and then it takes time, and sometimes they're returned to me many, many years later. I think for efficiency, also for the public to have confidence in the work that I'm doing. I find it very frustrating to not be able to talk about a lot of these files, and I think there'd be an education component to be able to say, you know what, this person has been late 10 times in their last 10 registrations. Enough. Let's do a monetary penalty. And so these are ways that, we could improve the regime. And my colleagues in provinces have that power. I don't.
Thank you. In 2024, you said that lobbying act need to be reviewed every 5 years. Do you still believe that the commission should be prioritized reviewing of the lobbying act? Do you still believe that should be happening? And secondly, what do you think the scale and scope of the review should be?
Okay, so the Act says that it must be reviewed by this committee every 5 years. The last time that happened is in 2012. So when I came here for my first nomination in 2017, I was asked, can you be ready in the spring of 2018? I said, I'll do my best. I will have been in the job for just a few months, and I was ready. I was asked in 2021 if I could share where I was at in my recommendations. So I shared a preliminary reports on my website. I shared it with this committee. I'm sure your clerk would have access to it back in 2021. It's a mandatory obligation to review, and we've lost 2 opportunities to continue to be improved and to be at the forefront. So yes, of course, I believe that the review of the Act needs to continue to happen. The scope, I think we should look at how to improve it from top to bottom, because every recommendation has an impact on the rest of the Act. So I do think that it should be a complete review.
You mentioned that often you have to send files to RCMP. Are those the activity which are criminal in nature, or is it every file that need review, you have to send it to the RCMP?
So the Lobbying Act says being late to register is an offense. Providing false information on the registry is an offense. Lobbying while unregistered is an offense. Lobbying while prohibited from lobbying is an offense. Everything is an offense. So if I'm in an investigation, I must, and I find that breach, I must send to the RCMP. Now, what I do is I just don't investigate. Every time somebody is late, and there's 5, 6, 7, 10 people late a week, I just accept that registration for transparency purposes. But I'd like to be able to impose penalties, because eventually they're constantly late, and it's not good for transparency. Transparency delayed is transparency denied, so we do need to improve our regime. But every breach of the Act is an offense that I must suspend and send to the RCMP.
Thank you.
They're not all created equal, and I think we need to fix that.
Thank you, Ms. Bélanger. Thank you, Mr. Sene. You mentioned, Ms. Bélanger, that 8,800 lobbyists have been registered in 2024 to 2025. Last time you were here, you've seen a significant spike in registered lobbying. So can you do a comparison off?
Probably an increase of 5%. I think we were at 7,700 the previous year. So there seems to be an increase of 5% every year. Now, the monthly communication reports went down from 34,000 to 31, but that's normal in an election year. Like technically from January to April this year, there were really a lot less monthly communication reports.
Are you able to supply the committee from a period, say, from 2015 to 25? Can you do that for us? Okay,
yes,
thank you.
Yes, absolutely.
All right, that completes our first round. Mr. Cooper, you're going to start us off in the second round for 5 minutes. Go ahead, sir.
Thank you, Mr. Chair. Commissioner, on September 19th, 2025, the Globe and Mail reported that a real estate executive, a lobbyist, and a banker, who all happen to very conveniently be Liberal insiders, held an exclusive reception for Liberal MPs and cabinet ministers during the recent Liberal National Caucus retreat in Edmonton, where Liberal MPs and cabinet ministers were invited for a beverage to discuss politics. Now, to be clear, lobbying rules require lobbyists to report a meeting with public office holders, even if they are oral and arranged, correct?
Yes.
And under the Lobbying Act, reportable subjects include communicating with a public office holder regarding the development of any policy or program of the Government of Canada, the awarding of grants, contributions, or other financial benefits, the awarding of contracts, the making or amendment of any regulation or introduction of any bill. It's pretty broad. Have I got it right?
Yes.
Okay. Now, with respect to this reception, has any return disclosing communications with one or more public office holder on a reportable subject been filed with your office?
I don't believe currently, but they technically have until October 15th to impose any monthly communication report. So they have to do it by the 15th of the following month of when the communication would have occurred, if there was a communication during that period that would meet the definition that you've set out.
Now, can you understand why I and a lot of Canadians would really have a tough time believing that a reportable subject would not have come up in that context, with Liberal MPs, cabinet ministers being invited by a real estate executive, lobbyist, and banker to discuss politics?
So, well, the thing I have to say here is I've looked at that article and I've gone through it, and most of the people that were involved in this are not registered lobbyists. So that's the first element. The second element, if there was a registrable subject discussed, it would have to be on behalf of their employer or a client. So that's a second step before they would need to register. Having said that, if you don't mind letting me finish, when these types of events occur and that the people that are not the ones that are organizing it are not the actually registered lobbyists. We do have a section in the Code of Conduct, 4.3, that says very clearly, you should not be lobbying people that possibly have a sense of obligation towards you. And some of the examples in there are because of gifts and hospitality that go beyond the rules. And I put that in there because, and that's another conversation we'll have during the ledge review, I do believe there needs to be corporate accountability, not just lobbyists' personal responsibility and accountability under the Act and the Code. So,
speak about a sense of obligation.
Yes.
Also in the Code, that encompasses political work. Is that right?
I do have a section specifically on political work, yes.
And here we have 3 individuals who just happen to sit on the Liberal Party executive.
And because of that role, it's maybe they're not lobbying, though. I don't know what occurred during that meeting,
yes,
but for sure, if there are lobbying, then there's possibly some issues there, yes.
If there was technical compliance with the Act by the organizers of this reception, if you're in their position, why would you hire someone to lobby cabinet ministers to talk about a reportable matter, a matter that would otherwise be reportable, if you can host a reception, buy drinks, and use your position of influence to spend time with a cabinet minister or an MP to make your case because you're a Liberal insider? I mean, why would you pay someone when you can go directly and do what a lobbyist would do, but you just have a lot more access and a lot more influence? That seems to me to be, at least on the surface, what happened here.
But facts matter, right? So it really will depend on whether these individuals are there to represent anybody, and that's how the Lobbying Act applies, and it works right now.
But it's certainly, there's a lot of smoke there, isn't there, on the surface? And even putting aside the specifics of this event, there's a major loophole in the Act for the scenario that I just described.
I do agree that we need to have that conversation about corporate accountability and responsibility, yes.